Hello, my name is John Milburn. I'm your course coordinator. Today I'd like to speak to you in relation to Chapter 2 of Environmental Law in Australia by Jerry Bates. In this chapter, Bates discusses the issue of governance and the law, the doctrine of separation of powers, the concept of the Crown, native title, overcoming property rights and compensation for acquisition of property, the social context of environmental law, framing environmental policy, the role of science, assistance by non-government organisations, the question of compensation and when it should be paid for environmental restrictions, translating environmental policy into environmental law, and the role of Parliament, the executive and the judiciary, which comes back to the issue of the separation of powers. So Chapter 2 is headed The Social and Legal Context in relation to environmental law. So the purpose of the chapter is to explore influences that impact on the making and implementation and interpretation of environmental law. Bear in mind, of course, that there are the three areas of environmental law, that is Parliament, the executive and the judiciary, and we'll keep coming back to that separation of powers. So when we talk about the making of laws, we're talking about Parliament's involvement. When we're talking about the implementation of those laws, we're talking about the executive. And when we talk about the interpretation of environmental law, we're talking about the executive. There are some crossovers. For example, there are clear merging of some of the roles of Parliament and the executive. Ministers who are voted in become the head of the executive at a Commonwealth level. And when it comes to enforcing environmental laws, each one of the three powers in the separation of powers have a role to play. Parliament will make the laws. It's up to the executive to enforce those laws by bringing a prosecution, and the judiciary then considers that prosecution and effectively provides the enforcement remedy in appropriate circumstances. Now let's go back to the beginning. Our style of government, our Western style of government, capitalism, was inherited essentially from the British model. And consequently, our legal system reflects a desire to protect the social values which are associated with this form of government. At settlement, the Australian law was reflective of the English common law and also the legislation of the United Kingdom. We talked last week about the difference between Parliament and also the common law. And you might recall that we said that law is created either by Parliament through legislation or through the courts, through decided cases, which is common law. In the context of environmental law, just remember that common law is first and foremost there to recognise and protect interests in private property. Common law of itself has little to do with framing environmental policy and therefore little to do with translating that policy into law. And that's the way it should be. Parliament is created as a result of the election of individual members into that forum, and they do so based on policies which have been developed and voted upon. Judiciary aren't there to reflect, generally speaking, the policy of governments. Well, they're not there to reflect the policy of government. There is one exception to that, and that is the whole concept of judicial activism, which I'll speak to you about later. So common law was not there to effect or reflect public policy in terms of environmental reform. It was there to protect private interests. So environmental legislation has been introduced precisely because of the inability, or perhaps the reluctance, of common law to effectively recognise the environmental values of land as distinct from the administration through executive or through the enforcement of the courts. So Parliament makes the law, executive implements the law, and the judiciary interprets and therefore perhaps to some degree enforces the law. I mentioned before that there is some overlap, and a member of Parliament who is also a minister has a foot in both camps, so to speak, and the distinction between the role of a minister in a parliamentary capacity as opposed to the role of a minister in an executive capacity is clearly defined, but it is the same person fulfilling that role. Now, when we talk about Parliament or we talk about the executive, bear in mind that that is distinct from the concept of the Crown. And the Crown is an important institution in Australian law. Ownership and possession of all land and natural resources in Australia vests or derives from the Crown. The Crown is perhaps a funny concept to try and understand. It's used in a criminal law context when an indictment is presented against an individual in superior courts. It's said that the Crown is the prosecuting authority. In a property context, the Crown perhaps can be regarded as something like the concept of the household in a private setting. So, for example, members of a family will come and go. People are born, people pass on, children grow up and they move away from home. So the family that occupies a home at any one time can vary from time to time. But the thing which remains constant is the concept of the household. This is the family household. This is the Smith household. It might be occupied by different people at various times, but the concept of the household remains. And perhaps the concept of the Crown on a national level is similar to that. Parliaments come and go, but the Crown as an institution and holder of property remains constant. I mentioned before that it's Parliament's role to introduce laws, the executive to enforce those laws. The judiciary has the role of interpreting those laws, but sometimes through judicial activism, it goes a little further. Perhaps the best example of that is the High Court in the Mabo decision rejected terra nullius as a basis for denying Aboriginal entitlement to land at common law, and held that a form of native title could survive colonisation until extinguished by an exercise of sovereign power from the Crown. That extinguishment could occur by a valid exercise of sovereign power where it was inconsistent with the continued right to enjoy native title, that is, for example, by a grant of freehold title to others. So in the Mabo decision, it was the courts, not Parliament, that took the step of effectively abolishing the principle of terra nullius. Terra nullius, you'll recall, is the concept which suggested that Australia was settled rather than overtaken, as it were. Now, the Commonwealth Government responded to the Mabo decision by enacting the Native Title Act of 1993, Commonwealth legislation, which essentially took what was decided in Mabo and extended it further and gave it a legislative effect. The importance of that concept is this, that when it comes to a conflict of laws, Parliament will override or stand above, if you like, the laws which are created through the common law, through judges. In 1993, the Commonwealth Government of the day had an important choice to make. It could have accepted and acted upon the Mabo decision and enshrined that decision through legislation, which is what it did. It could have gone the other way and created legislation to effectively overturn what had been decided by the courts. Now, just in terms of the Mabo decision, any finding of continued existence of native title is significant to environmental law because there are different regimes that apply when it comes to the management of land and natural resources when Aboriginal landholders are involved. Because of the extent to which the Crown has interfered, says Bates, in land and natural resources management over decades, it is notoriously difficult to establish continuing native title, particularly exclusive title. The question of native title and the legislative controls that can be brought into effect, which might affect native title, have been the subject of a number of decisions. The Wick decision is a very important decision which deals with the interest of leasehold entitlements. Also, Yanner against Eaton, 1999, is a local government decision which dealt with the question of the extent to which legislative control over natural resources might extinguish native title rights in relation to traditional hunting and gathering. The High Court carefully considered the situation and came to the conclusion that the establishment of a royalty regime was not taking property over wild animals in that instance. So, I commenced my commentary this way, that common law protected property rights through legislation that can be overcome, and through legislation, environmental law can be advanced and policy implemented through legislation. What that means inevitably, however, is that where we have environmental law enacted through legislation, it will have the effect of overcoming the rules of common law. And the common law, as you'll recall, effectively provided that landowners could be free to exercise their proprietary rights within the boundaries of their own property. So, legislation can have an effect on the way in which private owners of property can deal with and enjoy that property. I'm going to be getting very close to the topics discussed in that wonderful movie, The Castle, now, where I mention, commenting upon what is in Bates's book, that the Commonwealth Constitution clearly specifies or stipulates that the laws of the Commonwealth may affect an acquisition of property, but must do so on just terms. So the first task of determining whether the laws which are created to protect the environment thereby create an effect where property is taken from a landowner, we must consider firstly the nature of the entitlement which is being acquired, so to speak, as property through such laws. The concept of property denotes something which is permanent and secure. We contrast that to a permit or a license which might be regarded as revocable at any time. To give you an idea of the distinction between what might be regarded as property and what might be regarded as a revocable license, there is some commentary in the text, and I refer particularly to the Environment Protection Authority against Rashley, where the Australian Capital Territory Court of Appeal reversed the original decision. And at paragraph 2.18 of Bates, there is a statement of what was said in the court, and it says, on a careful review of the authority, it seems that at common law, an owner or lessee of land while they may have a right to access water flowing below that land, does not have property in the water. In other words, a restriction imposed by a regulatory regime, in this case a licensing regime, would not amount to an acquisition, even if a license was refused. Okay, let's see if we can break that down and make some sense of it. We start with the idea that if someone owns property, they can use that property as they see fit. The problem from an environmental law perspective is this, that people use the property to profit from that in a business sense, and they might thereby pollute the waters which are adjacent to that property. The common law, through the court decisions, offers no general protection to members of the public from an environmental perspective. Parliament comes in, creates laws which advance environmental policy, but in doing so, those laws may have an effect on the use of the landowner for the use of property. Does it mean that the Commonwealth has, by introducing those laws, acquired property? Let's take an easy contrast. If the Commonwealth enacted a law that affected a compulsory acquisition of property, then the person whose property was acquired is entitled to compensation for the value of the property. They had real estate, now they don't, therefore they get money. They get their money at a rate which reflects the just terms, the wording used in the Constitution. So that's pretty simple. But what if environmental legislation limits a person's ability to use property by affecting a licensing regime? Does that licensing regime have the same effect of an acquisition of property? The approach of the Australian Capital Territory Court of Appeal in Rashley was effectively confirmed, this is at 2.19, by the High Court in ICM Agriculture Proprietary Limited against the Commonwealth, 2009, High Court of Australia 51. In this case, the majority of the court held that a reduction in volumes of water allocated by aquifer licences, which had replaced old-style bore licences, did not amount to an acquisition of property. There can be no acquisition unless there is some identifiable and measurable advantage which is derived by another from or in consequence of the replacement of the plaintiff's licence or reduction in their entitlements. The plaintiff's rights under the bore licence did not return to the state upon cancellation of those licences. I know it can all be a bit tricky. Try to break it down, have a look at those two cases, read paragraphs 2.18 and 2.19. See if you can identify the distinction and be prepared to argue that distinction should the need arise in an examination-style question. Remember, when it comes to answering legal questions, you don't necessarily have to get the answer right, as in, I agree with you. Much more important is your ability to identify the legal issues and mount a convincing argument one way or the other. All right, let's move on. Now, this is an important point. At 2.20, Bates says that courts often see themselves as providing essential protection to the rights of the individual against overzealous use of governmental powers. So there is always this, if you like, tension between Parliament and the courts, and that tension, for want of a better term, is reflected in environmental law and the difference between enforcement and policy. All right, now just in terms of the question of whether property is acquired or not, that is also discussed at paragraph 5.32 of Bates. So be aware of that should the need arise to discuss the question in an examination or an assignment context. In essence, it's fair to say environmental law results in determining environmental policy and then affecting that policy in law. When it comes to environmental policy, there is the political aspect, there's the social aspect, but very importantly, there's the scientific aspect. And science is important in creating environmental policy, creating laws that are based on that policy, and then science is important in providing evidence in legal cases. Science also has a role to play in terms of the work which is undertaken by non-government organisations. They perform important functions in raising community awareness and exerting political pressure on governments, which then has a role to play in the formulation of policy, implementation and enforcement. In his text, Bates provides an excellent example. Because the federal government was at one stage unwilling to enforce prohibitions on whaling, which were embodied in the Environment Protection and Biodiversity Conservation Act of 1999, it was for the Humane Society International to take its own enforcement action. And that organisation effectively took on the role of prosecutor, and that case is reported in Humane Society International Incorporated against Kyoto Sanpuka Keisha Limited. It's 2008 Federal Court of Australia 3. Have a read of that if you're interested. And the important point that I make there is twofold. Firstly, science has an important role to play in terms of not only assisting in the creation of policy, but sometimes in directly in enforcing that policy as well. And science has a role to play in the case where evidence is required of a scientific nature. So science provides some further insight into the way in which environmental law comes into existence and is enforced. The difference between the common law and the legislation, as I've mentioned, is all about intrusion into private rights and the question of whether or not those people should or should not be compensated as a result of the way in which environmental law, planning rules, pollution control has an impact on those private landowners. And that's a difficult question to determine, as we've said. So if the restriction on the land was compensatable, then there are questions of how much should be paid and on what basis. There are issues of equality, and there are issues of how do we compensate business trying to encourage investment and offset that against the way in which people want the environment protected. It's not easy to do, and no doubt you're aware of different schemes that have been implemented by various governments to try to adjust or compensate landowners for environmental restrictions, even though some of these schemes have no legal imperative to provide just terms compensation. Previously, I talked about the constitutional obligation imposed on governments to provide compensation on just terms where an acquisition was made. That doesn't necessarily apply where there are environmental adjustment schemes brought into effect as a result of Commonwealth or other legislation. Let's look at an example. In Spencer against New South Wales Minister for Climate Change, Environment and Water, which is reported in 2008 New South Wales Supreme Court 1059. The plaintiff, that is the applicant if you like, the plaintiff, had been offered a structural adjustment payment to purchase his property, which was affected by restrictions on clearance of native vegetation. The plaintiff's claim was, in reality, that the offer did not adequately compensate for the loss of business opportunities brought about by the restrictions on the clearing of native vegetation. The unfairness claimed by the plaintiff in that case was that the government had legislated in such a way that rendered otherwise legitimate activities of Mr. Spencer to be such that they were no longer viable as a business. Now, while all members of society must accept that there will be restrictions on activities for the greater good, the question is when those restrictions prevent or prohibit a business activity which was previously legitimate from further operating, should there or should there not be compensation payable as a result of the introduction of those restrictions imposed? Is society, for example, asking people like Mr. Spencer to pay for the benefit of society without society compensating him in this case? So the real problem with creating expectation that any intrusion into the common law or statutory rights in pursuit of environmental policy will be compensated is that governments will not be able to or not want to make sufficient money available to fund environmental programs, and therefore the objectives will not be realised. So translating policy into environmental law needs to be done in the context of the cost. If there is a cost to implementation of environmental law, the next question is, who bears that cost? Should it be the private landowner who is directly affected as a result of the introduction of that law, or should the community generally bear that loss and provide appropriate compensation to that landowner? These are important questions that are raised in Chapter 2 of Bates's textbook. Now, in environmental law, statutes are primarily used to create legislation where no regulation previously existed. Statutes create specialist courts or tribunals to hear environmental law cases. They give power to executive agencies to implement those laws and regulate activities that may have an impact on environmental law. They give power to government agencies to manage natural resources and provide for public participation. They give power to government agencies and therefore the courts to enforce those laws and deal with disputes in relation to environmental matters. So, in summary, in environmental law, in Chapter 2, we're dealing with the separation of powers, we're dealing with the way in which laws come into existence, we're dealing with the conflict, if you like, between the rights of property owners and the need to consider payment of acquisition of compensation for acquisition of property rights. We need to consider what is a property right, and does the fact of licensing of itself mean there's an acquisition of property. Enjoy reading Chapter 2. There's a lot of important material in there, and I do look forward to any discussions that you might have in relation to the content on UCRU or perhaps Moodle. All the best. Bye.